Hello, this is Kunal from Diorama International Film Festival, and today we are going to discuss protecting IPR in cinema. Let me just introduce you to our moderator, Carlyta Mohini. She's an advocate, she's a singer also, and she is from Brazil actually, but she's practicing and working in India right now. So I'll hand over this session to Carlyta and to conduct the session further on. And I welcome my eminent guest on this panel. We welcome you to Diorama Source.
Thank you.
Thank you, everybody, and good evening to all our viewers. Today, on behalf of the eminent legal panelists of our country who are contributing their time to the discussion on the evolving intellectual property right, IPR, and the copyright law of India. The subject is IPR in cinema, which is Indian cinema, in the ongoing Diorama International Film Festival. And today we are very, very glad to welcome Honorable Mr. Justice Tapen Sen. And before that, I must bring into everybody's consideration that Justice Sen recently had an eye surgery. And in spite of that, he has been able to contribute his time for IPR in cinema. Sir, we are highly obliged and appreciative, and thank you. Before we progress, we have got Honorable Mr. Justice Tapen Sen. He has served as judge in Calcutta High Court, Punjab and Haryana High Court. He has also served as a president of Jharkhand State Consumer Redressal Commission and also Jharkhand High Court. Since his retirement, Justice Sen is regularly arbitrating commercial disputes between corporations. Then, our second speaker is Honorable Justice Mr. Rajive Bhalla, most welcome to the panel.
Thank you.
Mr. Justice Rajive Bhalla has been the judge of Punjab and Haryana High Court and chairman of Punjab Education Tribunal and Punjab RERA till 2019. Since then, he has been regularly appearing before the Honorable Supreme Court of India as an advocate. He regularly discharges functions as an arbitrator in commercial arbitration for private and public sector enterprises. The third eminent speaker is Mr. Ameet Datta. Most welcome, Mr. Ameet Datta, to this panel of IPR in Indian cinema, rather
Thank you for
IPR.
having me.
He is a partner of Saikrishna and Associates, and a very important part, he specializes in copyright, trademark, and design litigation, as well as technology, media, and entertainment and trade. With over 20 years of experience in international property litigator and lawyer, he has advised leading Indian and international industry clients on diverse matters related to content creation, protection, and monetization. Amit, in last 10 years, has actively engaged in policy reform around the copyright sphere, having deposed as an expert witness before the Parliamentary Standing Committee. Welcome, sir. Welcome. This is amazing. Our last and the fourth speaker is Mr. Siddharth Srivastava. Welcome, Mr. Srivastava.
Thank you.
Mr. Srivastava is a counsel practitioner in the Honorable Supreme Court of India and partner at Seven Seas Partners LLP. He specializes in commercial litigation, arbitration, and intellectual property law. He represents film production company, Bollywood media houses, film festivals, and film professionals, both India and internationally. So, welcome, Mr. Siddharth Srivastava, once again. And now we go into the very vital aspect of our panel today, that is IPR in Indian cinema. And this question goes to Honorable Mr. Justice Tapen Sen. Justice Tapen Sen, in recent years, there have been multiple instances wherein courts have imposed restrictions on films and TV shows for hurting the sentiments of communities, both ethnic and religious. Speaking as a former judge, in the light of the fundamental right to freedom of speech and expression, would you say such restrictions should be enforced? And what would you say on the contours of the fundamental rights of India?
Thank you. Uh, well, first of all, I wish to thank the organizers of Diorama for letting me speak here today. It's a great privilege and an honor. Now, to answer the question that has been posed to me, the freedom of speech and expression, they're both guaranteed under Article 19 of the Constitution of India. And this undoubtedly is an ingrained freedom of every citizen. But to understand this right, you have to understand the ethos behind the right. And in order to do so, we must remember that this subject was one of the most passionately debated and deliberated article by the framers of our constitution. Naturally, because the debates of the constituent assembly took place in the very background of having been under a repressive authoritarian regime for over 2 centuries, where people practically had no right of expression or speech. Therefore, when understanding its fetters, one must also keep in mind the very spirit that was embodied while these debates were going on. While our constitution has made an express provision protecting an individual's freedom of speech and expression, the courts, however, over the decades after independence, have played a very vital role in shaping and protecting these rights. And under the current interpretation, this right cannot be curtailed. I repeat, it cannot be curtailed unless this falls what we call a proximity test, which was devised by the Honorable Supreme Court way back in 1989, which requires the relationship between speech on public order to be direct, or in the court's language, as direct as a spark in a powder keg. India has a unique society in the sense that we are a beautiful symbiosis of modern and traditional culture. It is fast witnessing an entire class of people getting added to the middle class, which has emerged over the decades as the largest economic strata in our country. I'm sure Justice Rajive Bhalla would agree on that, because we both belong to the middle class. First generation schoolers
Mm,
are increasingly moving to cities to either complete their studies
correct.
or work in India's flourishing corporate sector. This has brought our society on the crossroads of cultural change,
Right.
which will only advance us as a society over the coming decades. However, despite these advancements and these changes, our societies still run on the basis of a myriad age old customs and traditions, which makes subjectivity, this is important, subjectivity in the way our speech and expression is perceived. This becomes a very tricky issue also. To put things simply, what I see and appreciate as art may not find the same or even a remote level of appreciation in the eyes of someone else. Therefore, when it comes to art, literature, and films, this freedom is automatically weighed in the context of individual or societal perception. This is because what may be moral for some might turn out to be immoral for others.
Correct.
And therefore, coming back to our right to speech and expression, all rights are subject to the Constitution. And there is obviously a concomitant duty on every individual enjoying that right to do so responsibly and not to the prejudice of others. Now, on the subject of cinema, what is a cinema? A cinema is nothing but a modern form of expressing a thought or an idea. Earlier, the concept of propagating an idea or a thought was through the medium of books. This can either be, books can either be pious, this idea can also be pious, the thought can also be pious, in which most cases it can also be evil. As we have seen, for example, the film Triumph of the Will,
Mhm. Yes.
a Nazi propaganda film.
Right. Right.
Uh, we have also heard of terror camps running various vicious tapes showing war brutalities to hapless individuals with the intention of misleading them. In today's era of cyber crimes and terrorism, this interplay between freedom of speech and expression, it becomes so challenging, both from the perspective of states, including courts, as well as from the perspective of filmmakers. This is because cinema or films are a mode of expression of their thoughts or ideas. And this is very powerful because this is the way their ideas get disseminated to a large part of society. And since it is audio visual, naturally it would mean that it reaches even to those who have no literary background at all. It is exactly for this reason why this becomes tricky, as it can be used for both good and bad means. Because it is also a tool which is capable of planting an idea or a thought in the mind of the viewer. An idea which can be great as well as can be very disastrous at the same time. There have been a great deal of study on the nexus between films and their influence on the minds of individuals. Now, the art of filmmaking is an art which at times attempts to portray things or actions which may, for instance, may be moral to some, may become moral to some, and yet immoral to others. For example, the 2014 film Unfreedom,
Mhm.
which was banned in India,
Right.
came to an apprehension only that the film could ignite unnatural passions and incite rapes and communal violence. Despite this apprehension, this film was received well and was recently released internationally on Netflix as well. This, in my opinion, is stretching the concept of societal harm a bit too far. While putting rigors, the ethos behind Article 19 should always be borne in mind, and any curtailing ought to be made strictly in the sense of the proximity test. It should always be borne in mind that filmmakers are not impediments for societal development. They toil hard behind the expression of their idea, behind their cameras. They put in tons and tons of sweat and labor, and also tons of their gray matter and hard earned money into their films to finally produce something which reflects the mood of a section of the society. In the case of, say, for example, in the case of unfreedom, some may like it, some may not like it.
Right.
But the essential feature of such a product is that it rarely imposes its ideas on those, who do not who do not appreciate it. Take it or leave it. If you don't
Correct.
like it, don't like it, don't see it. Therefore, the concomitant duty of the filmmakers to act responsibly in their pursuit to express their thoughts and ideas, and being an intellectual class of society, they should also assert a certain degree of care and diligence into their final product.
Mhm.
Indian society is coming of age. It's becoming matured day by day, and it's becoming so very fast. Therefore, time has now come to readjust our thinking hats, thinking caps, and also readjust our thinking on the scope of this beautiful freedom. In my opinion, captions such as "for adults only" or "for universal viewing" UV, they should be replaced with the words "you are free to watch it, you are free not to watch it." In this 21st century, banning the expression of ideas as ills of human society under the excuse of laws, in my opinion, should be done away with totally and completely. Uh, and our country, with with millions of brilliant minds, should be allowed to watch whatever they want to watch instead of telling them what to watch. I mean, we are big enough, we are adults. They should tell us, instead of, as I said, instead of writing out the caption "universal UV" or "for adults only," they should say you're free to watch. You whether you watch it, it
That's a
contains it contains
fantastic suggestion.
and therefore you are free either to watch it or not to watch it. This will only uh, foster creativity and promote the suppressed talent that abounds in our society. Nobody can say we are anything anyway less than Hollywood, than Hollywood. Yes, we are equal. We are better and equal at times. Freedom of speech and expression, like Article 14, which is our right to equality, therefore, is a sensitive approach, developmentally sentimental, a sensitive approach. And in these times, this era of modernization, any fetter upon our freedom must be carefully weighed in the context of the ethos behind having it in the constitution. And there must be a great amount of leeway that should be given to individuals in their pursuit of speech and expression. When I say expression, obviously that includes films and so many other things. But however, it should be to the extent that it does not directly hurt or impinge
Hmm.
on the freedom of others.
Correct.
I think these are my views, and I hope I've been able to. Uh, I hope I've
Absolutely.
been able to
Absolutely. And
express my ideas and my feelings, and that too before a judge who is also
yeah.
a judge of the Punjab and Haryana High Court. So I hope I'm clear.
Perfectly put.
My,
You have aptly portrayed the entire, the significant value of the, the IPR, which is and the best suggestion which you have given. And I'm sure that the Indian Performing Rights Society, which we have in Bombay, the suggestion of the very fact that if you want to see a film, just go and see the film. And if you don't
exactly.
want to see the film, don't see the film. The
Right.
moment there's a restrictions, the viability, the curiosity, whether it's a bad or good, is going to multiply. And it, as you said aptly, that it can bring in good, it can bring in bad. To somebody, it's a bad thing is good. To another body, the bad thing, the good thing is bad. So it is their right of choice, and it's a right of freedom expression, as aptly said by you, Justice Tapen Sen. I'm so grateful and appreciate from the panel that it is amazing to hear, and I'm sure that the viewers are going to really catch up onto the great suggestions which you have given, your opinion. Thank you so much, sir.
Thank you. Thank you.
Appreciate.
Thank you very
And
much. Thank you very
and
much.
please take care of your eye surgery, because vision is
Yes.
very, very important, and we have to be visionary. If you're evolutionary, IPR needs to be visionary. So, sir, take care
Yeah.
of yourself, and God
Thank you
bless
very
you.
much. Thank you very
God
much.
bless you. God bless you. God bless you. God bless you,
You
sir.
too.
Thank you, sir. Now we are coming down to the second speaker, as rightly said by Justice Tapen Sen, that, Justice Rajive Bhalla will but agree to it. That's what wonderful. But the question, Justice Bhalla, as we all know, in the present day and situation and the age, international property right has gained immense, immense importance. It's just like evolutionary. Everything which surrounds us, be it a movie, a song, or a video game, or a book, everything is intellectual property belonging to somebody or someone. Film production, I mean, that's a huge genre comprising of the intellectual property at each and every stage. Seeing this immense growth of international property rights, sir, what are your views and protection of IPR in this modern world of cinema, and as aptly said by in the world of freedom of expression and speech in Indian cinema? So,
Thank you
welcome.
very much for having me and allowing me this platform. We are used to very sterile legal seminars, and I'm happy to be here with to discuss something about intellectual property regarding films. But before I go to what answer your question, I just add a few, call them a caveats, or some things regarding what Tapan had just said. I take the liberty of calling him Tapan because we've been together in High Court and shared a bench, shared lots of things in the Punjab and Haryana High Court. See, the question that arises is when you talk about freedom,
Right.
who's going to draw the line? Who's going to make the rules? Who's going to set down a criteria? Or do we need a criteria? Do we need to set down a rule? Or do we have an absolute freedom? I personally am a votary of absolute freedom, because
Mm-hmm.
with the good will come the bad. If we do not distinguish between the good and the bad, I mean, how do we decide that? And if you remember, just a few days ago, the Supreme Court famously observed, if you don't like the channel, just switch it off.
Correct.
So, taking a few words from what Tapan had said, if you don't like it, you don't watch it. And banning anything, I mean, though this is maybe not the place for this discussion to take place, but banning anything sends it underground. Where does it go? Now, do we want to create Ravi Varmas, and do you want to create Mantos? Do you want to prosecute them for what they think, what their stories are, for what they paint, or what the movies they make, or whatever it is? Do you want to go that path? Now, why were all these people prosecuted? Coming back to the question of your answer, it was because
Right.
of an output of intellect.
Correct.
Their paintings, their writings. Manto, remember, very famous writer,
Mm-hmm.
prosecuted in India, prosecuted in Pakistan, even wrote in films when he came back, came from Pakistan, went back there. So,
Mm.
what were you being prosecuted for? Intellect. So, I'm just taking what Tapan has just said, taking it a little forward. But the whole question arises is, who is this person who sets the rules? Who is this person who decides what I must watch, what I must not watch, what I must see? That is the person that you need to identify. Output will always be there. Intellectual output is something you cannot stop. If you had no Marx, you would have no Russia. You would have no communism. You would not even had socialism as we now you know it in various states. So you
Right.
banned him, made him into something much bigger than what it actually was, applied to a small little Swiss canton. That's the actually example of intellect. Cinema, now coming to cinema. How I understand cinema is about 100 moving parts coming together to take you into a dark room, and the mystery of cinema just comes alive, and you're transported to a different environment, totally a different thing, and the story unfolds before you. So the first small flickers of cinema in the 1800s, in the late 1800s, and now today, to on my cell phone, I can be talking to you and at the same time watching a movie right next
Right.
to right here on my cell. So that's the path that cinema has taken, from the silent movie, then to music, to the Indian cinema coming from the tradition of almost like coming from a play to the local this thing, and now coming to maturity. Though of course I am a critic of today's Indian cinema. uh, that's a different
Okay.
matter. I do criticize it for the fact that it's lost its soul. Indian
Oh,
cinema is now a pale imitation of what the Western cinema is or was. I'm
multiple
sorry
times.
if there's anybody listening in. Please, I am a viewer, so you must take care of me, and I'm a consumer of your product. So it's a pale imitation. Indian cinema, the Indian intellectual listening output in cinema was very different. Or maybe you may say because I grew up in the 60s and the 70s, so maybe that's why I have nostalgia for those sort of that sort of cinema. So coming now back to the question,
Hmm.
protection of intellect is, in my opinion, not negotiable. The effort anybody puts in into coming out with a product which is a pure product of intellect, and there's no factory, there's no assembly line, there are no workers there, there's nothing, there are no robotics involved, it's pure simple intellect. And if you don't protect the intellect nationally and internationally, then the incentive to produce an intellectual story or an intellectual this thing is, I mean, it takes a hit as far as the person is concerned. He must be suitably paid. And in today's times where you don't travel for free on the road, you have nothing for free, everything is going to be now. So why should the poor fellow who's produced a movie or written a book or painted a a picture for you, why should he not be paid and why should he not be protected? Now, in my opinion, it's not negotiable. But the question that arises is, day in, day out, we violate the copyright of cinema, we violate the copyright of music, we
Mhm.
violate the copyright of the script writer, the dialogue writer. I mean, you see almost every day, all you have to do is to open YouTube, and I don't know why nobody is bothering to figure out how people are uploading songs with their only husband and wife dancing together, and songs being uploaded and people being, it's the whole thing is there. So it's a question of how many people will you sue and what will you do. So with these few words and my conviction on freedom, that freedom has to be absolute, no ifs and buts. You don't like it, so be it. It's your problem. I like it, it's my problem and it's my thing. With that, I think we can take whatever discussion forward.
Thank you so much. It was a very well, knit understanding our viewers are going to have, especially on the field of, entertainment. The second question, which has really created a kind of an uproar in our country, that is regarding the Sarabhai versus Sarabhai case. And recently, a Pakistani studio made a remake of Sarabhai versus Sarabhai, which is, of course, we all know, which is an iconic Indian TV show. Now, without seeking, number one, no license, no permission from the creators of Sarabhai and Sarabhai, which has been produced by Indian production house. In such cases, sir, what would you say is the appropriate remedy of an ingenious studio to stop or to sue creators of the remake, sir? This is really, I mean, very important. How do we stop them?
Uh,
Because they
for
would
anybody
continue.
for anybody who has not seen Sarabhai versus Sarabhai, I think you
Mhm.
should introduce the serial a little. There were four iconic characters, of sometimes
Right.
there would be five also. It's a story within a family and a very Indian Paki story. I mean, you can say it's a story which is very similar to India as well as to Pakistan. The characters are common. And actually, we've had this cross border fertilization happening. This is not the first time it happened. And it's not Indian movies which have been copied. We have also done our bit also. But the only difficulty over here is, I mean, we are not that innocent. If you look at our songs, there are so many of them which we've lifted, particularly are that Sufi music. Almost every Sufi song has been lifted from Pakistan, or every second. Okay, maybe I can be a little charitable to our venerable music directors and our composers, that maybe it's every second song which is lifted and not everyone, because there was some element of I mean, please, I'm not trying to be in any way dismissive of anything or anybody, but since Urdu is a very very fine, a language which expresses itself, it's very good at expressing emotions. So therefore, we have this habit of taking their Urdu renditions, turning them into Hindi. Now, in Sarabhai versus Sarabhai, actually, we can't do nothing about it, for the
Oh,
simple reason that they were signatories uh, to the Berne Convention, where, of course, our copyright is also protected there. But then either
okay.
you go to Pakistan to do it, or if they have an office here, then you sue them here.
Right.
But I'm quite sure they'll be quite clever enough and not to have an office there. And then we have another situation arising, which I think Mr. Datta will tell you eventually, that most of the streaming takes place not even from Pakistan or not even from India. Lots of them is offshore streaming coming from Singapore, Hong Kong. There is streaming taking all over the world. So who are you going to sue and where are you going to sue? I think we'll pass on the question to Mr. Datta also on that part.
I'll get on to that. And that means you mean to say there is no kind of remedies? Absolutely not. Justice.
Because they have to have a presence in India. Who will you sue? You
Okay.
can't sue the Pakistani High Commission, huh?
No, we can't.
Or you
So,
can't sue Imran Khan. I mean, you can't do that.
Well, thank you so much, Justice Bhalla. And when I bring in all your pieces together, the wonderful sharing which you have done on freedom and speech and expression, like who will draw the line? Who will draw the criteria? Who will draw the role? And on absolute freedom, and also you mentioned that there should not be no compromise on this intellect content cannot be negotiable. And another thing which you said in a very humorous way, pale imitation of Indian films from the Hollywood. So the thing is that thank you so much, Justice Bhalla, and I'm going to definitely put off the second question to another eminent lawyer, which is, of course, Advocate Mr. Ameet Datta. So, Mr. Datta, the as we all know that, and from our understanding, the law of copyright is a centerpiece of legal work involved in the film industry and our integral entertainment industry. And you have worked extensively for the Indian and international film productions companies as a very important counsel. What are the problems you usually encounter when it comes to copyright in film industry? The basic big problems.
Right.
Yes, yes.
Thanks so much. I must say it's not only a pleasure but a great privilege to be with Justice Sen and Justice Bhalla on the panel, and with my friend Siddharth as well, and you. And particularly, I must say that Justice Sen and Justice Bhalla's comments echo my continuing, sense of confidence in members of the judiciary, that this country has consistently sought to apply safeguards and to assert and make safeguards to freedom of speech more meaningful, where content has been concerned, across so many decades, whether it's the application of the community standards on the obscenity test, and the appreciation of art, books, film, and I take a lot of personal sort of, take away a lot of personal satisfaction, both these comments that were made, a series of comments that were made. When I look at the film industry, and I've been working with different parts and elements and constituencies in the film industry, unfortunately, the film industry seems to kind of occupy a large space, because it's both, as we popularly call it, a place where when one is depressed, one can go and elevate oneself, perhaps suspend reality for a couple of hours. As also, a large part of the music industry, which is my personal workspace and chosen workspace. 85% of the Indian music market derives out, unfortunately, I say that again and again, out of the film industry, but that's the reality. Now, one of the central problems that I've encountered where the film industry is concerned, in terms of a problem, is a distinct lack of understanding and appreciation by filmmakers of what is it that they're creating, and how do they approach it from a legal perspective. And the understanding that when you create a cinematograph film, it's a confluence of many elements. It's a confluence of many elements, and it's a product, if you want to call it in those terms. It's a product which is the result of a great degree of collaboration by multiple stakeholders, right from the man or the woman who wrote the original story to the script writer who adapted their original story into a screenplay, the director, the music composer, the lyricist, down to the music arranger who's not recognized under copyright law, etc. So it's a confluence. The approach in India from a legal perspective has been to give primacy to these what were called as secondary rights in Europe and in England. So the film and the sound recording was a secondary right. There was no doubt investment in making those products, but these were generally known as secondary rights, and your literary work, musical work, scripts, these were all primary works. We've had the reverse history in India. The primacy has been accorded to the finished product, and you've had a series of faltering steps that India has taken over the past 73, 74 years, both legally. The last big one was in 77, where the Supreme Court said that, look, ultimately the film producer who commissions and pays for something is the owner. I remember in that judgment, Justice Krishna here very valiantly tried and rather politically tried to preserve some sort of accompanying sort of judgment, which unfortunately was deemed to be obiter, or rather an observation. And he tried to give some space to the talent that creates lyrics, music, script that goes into a film, and tried to kind of say that, look, apart from the film, they have their own copyright. That didn't happen. And so the cinematograph film was approached as a all-encompassing bucket in which all rights were deemed to be subsumed. And when I say all rights were deemed to be subsumed, the performer's right, the lyricist's right, the music composer's right was never recognized. That changed in 2012 by what, in my personal view, is perhaps the most peculiar and the most landmark series of amendments to the Copyright Act. And India is probably the only country where Parliament decided that the market was so skewed in the favor of a few buyers, and you had creative talent that had created, outnumbered the sellers, outnumbered the buyers, that you needed a legislative tool to create the sort of monopsony that operated in the film and music industry, and sought to change this view of film, not as an all-encompassing work, but this beautiful blend of individual distinct legal rights that, when put together, created another distinct legal right. And that in itself was one of the desired sort of objectives of the 2012 amendment. To give you an idea of how this bucket approach has impacted, say, the music industry, I'll give you some figures. The worldwide recorded music market is estimated to be about $21 billion. There's a separate market called the publishing market. Now, the publishing market is very simply, there was a very famous French music composer who once walked into a Parisian restaurant. Beaumont is the name of that composer. He had his lunch, and he observed that one of his compositions were being played by a quartet in the restaurant. So the gentleman got out without paying the bill and was leaving the restaurant when the maitre d' stopped him. And his retort was, if you can play my music for free, I can eat your meal for free, and I don't need to pay you. And that led to the creation of the publishing industry. And so publishing industry is a series of rights that are linked to the lyrics and musical compositions that are created in music. And these are the rights of the lyricist and the composer. And these rights are created separately. So if you go to, say, England, and you have a sound recording that is being broadcast over radio, you have two licenses that have to be paid. One to the record label, and one to the owner of the lyrics and music which are incorporated in the recording as the publishing and the performing rights. So there are two licenses. India was perhaps the only country which, through a series of misfortunes, didn't recognize that. And so the result was that an Elvis Presley estate, or rather Paul McCartney, would get hundreds of $millions as the owner of the lyrics and the compositions that he made. Or a John Lennon's estate would get hundreds of $millions. Whereas creators of music, film music in India, never got any royalties, etc. As a result, the Indian music industry, which is 85% film music, coming from the film industry, is valued at 1,300 crores, barely 130 million. Whereas a Ghana.com, which plays music, it streams music, is a unicorn valued at $1 billion. So you look at the you look at the result of the lack of recognition of individual stakeholders and a lack of monetization of the individual constituent pieces of film, including its music, which in the Indian context is as important sometimes as film. You often peg a memory of a film to music, to a Sair Ludhianvi who wrote that film or that song or that music for that film. And so from that perspective, this approach has been problematic, and I'm hopeful we see signs of change where film producers and production houses, which are more corporatized now, which have built in international practices, are more open to recognizing individual stakeholders and their contributions, one, and the realization that individual constituents of film can also be monetized. So hence, following this subsumation sort of approach is perhaps not within, not only the international perspective, but certainly contradicts India's own, as Justice Bhalla has pointed out, India's own standing as a member of the Berne Convention and various other treaties. And we are fond of saying in India that municipal law will always trump our treaty obligations. So while we undertake treaty obligations, municipal law, even if it contradicts, will trump. But unfortunately, that has had a direct result in a stunting, I would argue, of the film industry and the music industry, where creativity has not been, not had the opportunity to explode and room to grow because of the constraints imposed under a perception, assumption, or an interpretation of law for so long, which I hope will change as time goes by because of the amendments, etc. And I think the second problem is, again, a lack of international practice. Contracts and chain of title, effectively have always been problematic in India. It's a lack of best practices from a practical perspective, which India has always had. It's always been a nightmare to look at contracts, the ambiguity around contracting, etc. Has always been problematic. And again, that you see signs that will change. As an IP lawyer, I have to confess I've spent maybe 15 years of my 24 years as a lawyer crying about piracy, because that is what IP lawyers are supposed to cry about, it seems. But I can tell you that the nature of piracy has changed. You had your bootleggers in various well-known markets where one could get CDs copied, etc. With the removal of this physicality of copyright into the digital domain, digital copyright has become far more insidious and it's much faster. You can actually have films. I've seen films which have been released before the formal premiere and release, which are already uploaded and have got maybe 10 million sort of streams, streaming websites, cyber lockers, all different kinds of websites. The good thing is that courts in India and courts in England have actually taken a leaf out of, and been very innovative in some offshore website blocking cases. But as Justice Bhalla correctly stated, you can't catch the guy who's actually doing it. The root or the heart of the piracy operation is probably sitting on a nice, warm, lovely beach in Antigua or someplace, who's just uploading, films that he's received via a file sharing service, and you can't actually go and kind of catch them. But what India is doing, like England, is blocking as much as possible. There's always limitations to technology. Blocking access to pirated contents by blocking orders or website blocking orders, to the extent where the courts in India have now allowed dynamic injunctions, where on affidavit, which is again taken very seriously in with my experience, given some of the cases that I worked on, where with full responsibility, counsel is required to place an affidavit on record identifying additional websites. Because a lot of the websites change and they flit between mirror websites very quickly. And that seems to work for a period of time. And, I think more innovative ways will be needed to be found. But I'm glad to say that when the law did not allow for this, and the law did not catch up in explicit terms, our courts have always been very, very agile, very adaptable to protecting intellectual property rights. In fact, I often argue with my American and English colleagues that some of our judgments that come out stand shoulder to shoulder, if not head over shoulders, where the protection of intellectual property is concerned.
Thank you so much, Mr. Ameet Datta. But the second question, which is almost on the into a very important line on the topic which we are discussing right now, is that owing to your vast experience as an intellectual property counsel, what are the general ways and means you recommend through which international property right, the film industry can be protected?
Yep.
Film industry as a wholesome.
I think one of the great perceptions, or rather misperceptions about intellectual property, is that it's a untrammeled, unrestrained, uncontrolled monopoly. That's not entirely correct, because intellectual property laws themselves, in being codified, say in international conventions and municipal law, often had to face various constituencies who wanted protections and preservation of certain areas where intellectual property or this monopolistic power could not kind of enter. And so you have a very rich sort of fabric of what are known as exceptions and limitations, which provisions across, whether it's patents law, trademark, copyright, which prevent this monopoly power from asserting itself in unreasonable directions and in unreasonable areas. So and then you have statutory licensing, you have compulsory licensing, you have various provisions that limit and restrain intellectual property laws. Where it comes to protecting intellectual property laws, as I just said, the courts in India have been very agile with, say, website blocking to look at digital piracy. I'm not a great believer, of the criminal process where intellectual property law crimes are concerned, but one needs to draw a distinction between IP infringement and counterfeiting and piracy, because I've often seen that piracy is of two kinds. One is retail piracy, which is small kind, hawkers, etc., stuff from China. But warehouse piracy or wholesale piracy, which are effectively networks that converge generally with organized crimes or peripheries of organized crime, are a bigger problem, and those need to be addressed by more specialized investigative forces in India. You have various modes of protecting intellectual property, but I have often said to songwriters, for instance, that the easiest way of ensuring that you can protect yourself is when you write a song or compose music, is write it on a piece of paper, put it in an envelope, and send yourself a registered AD post, and keep that envelope unopened. That's your common folk equivalent of registration. Tomorrow, if you have somebody who comes around at a subsequent point of time and uses your work, you can use that unopened envelope as an instance or as evidence that you were there prior and you had thought and created this work prior to them. The more formal way is obviously to register copyright. It's only a prima facie sort of evidence that there are some details entered onto a register. It's not evidence of ownership, but at the same time, it's evidence of you being there with a work prior to the creation or claim creation by somebody else. So you can protect copyright by registrations as well. Ultimately, intellectual property rights, we've gone through a system where uh, IP protection mechanisms, the court processes, and understandably so in a country like India, were seen as luxury litigation. Given the weight of and the crush of other pressing matters that courts had to face, we seem to move beyond that. There is an understanding that intellectual property crimes are economic offenses, which is why they are predicate offenses included within the Prevention of Money Laundering Act as well. So, if there is a crime that occurs around an intellectual property violation, the proceeds from that crime will be capable of being adjudicated and seized under money laundering statutes in India as well. I've worked on one or two of those, and they worked. They've genuinely worked. And I find that ultimately protecting IP is the obligation of the IP owner. The state has little role. While the criminal process gives the police suo motu powers to take action, it's understandable that police forces would traditionally not be trained, not be aware, not have an inclination at first flush to protect intellectual property because they're kind of understandably kind of occupied with many other pressing issues. So ultimately the weight falls on the intellectual property owner, unfortunately.
Thank you so much, Mr. Ameet Datta, because there is so much we have come to know. The viewers, I mean, I will be so glad to know the intensity of this IPR which you just mentioned to round it up for our viewers. They should know about the safeguard thing which you said. The second thing which you said, which was very important, is a confluence. The Indian film is a confluence of many elements. Then you said that the difference of the primary right and the secondary right is so important, factual, and very important thing, which you have told us in a very detailed format. The other thing which we have really come to know is the publishing rights of the industry, and you have demarcated that between the lyricist, the composer, and the rights which they should deserve. And then eventually you said that the best thing which has happened was in 2012, where the landmark amendment came in, and that has really somewhere helped the lyricists, especially the lyricists as mentioned, and the composers coming into terms with each other and the film industry. The other one, which is so important, is the digital piracy. Many people that don't know, especially the viewers, they've come to know this new term of the digital piracy, which is so important to safeguard the creations. Another one thing, which I'm going to finish it later, and the thing which you said, which is so important again, that the film and the music industry and the division of the rights, which is so unequal, that has come down into this landmark amendment which has come in. And to all the viewers, please pick up Mr. Ameet Datta's way of securing yourself. If you're a lyricist or a composer or a songwriter, do not open your envelope. Do not open your envelope. You send that in a registered post and keep it unopened. And when, as an evidence, and when anything comes up, God forbid, you can always present this. Thank you so much, Mr. Ameet Datta, for your
Thank you.
most valuable time. It's been a pleasure to listen to you.
Thank you.
Thank you so much once again. Coming back to the speaker four, and the last one is a friend. And Well, you are also one of the quite a person who has done so much in film industry. So, Mr. Siddharth, as you know, as our viewers are, are aware, many a time, that film production houses find themselves in courts due to some artist or another alleging infringement of their intellectual property by production house. So, that what are your views on this, and how can anyone can safeguard itself against potential lawsuits causing, arising from such infringements? It's very important. How does it happen? How would you safeguard it?
Well, firstly, to begin with, thanks for
Thank
the
you.
very kind introduction earlier, Carlyta. I really appreciate that. And it's an honor for me to share the
Yes, yes,
platform with these eminent guests who have had
it's
a
an
long,
absolutely
illustrious
pleasure.
careers in their lives. So to begin with,
Yes.
indeed. So to begin with, the first thing that we have to understand is that the copyright is not given on an idea. It is basically given on the expression of an idea. So you may have thought of a nice story or a idea of a TV show or something on those lines. But that idea cannot get protection unless you have expressed it through a medium. So that medium may be anything. You might as well write a book, create a song, or it may be just a video of you narrating a story.
Mm-hmm.
But there has to be a medium of expression without which you cannot get a copyright. So to take it further, I would rather speak from a very practical perspective about the problems
Right.
that people face in the film industry. The first thing that we have to understand is that film industry is one of those only industries where creation of intellectual property takes place at every stage from the very beginning. So, to cite an example, when a team gets together to create a movie, they hire a location manager, and the location manager is sent to, say, a certain country or a state or a city to take pictures of respective locations where they can shoot. And this location manager, during the recce visit, he creates a portfolio of photographs. There may be
Right.
60, 70 photographs of different locations.
Mm-hmm.
And he shares the same with the team. Now, this portfolio in itself is an intellectual property belonging to the location manager. If I were to use the portfolio for this movie, I cannot use it in the next movie without taking his prior permission.
Mm-hmm.
So you see, from the very beginning, the creation of intellectual property is there. In the subsequent stages, there's you acquire music, you create music, create the background, the subtitles, the designs of the sets, etc. Every stage involves creation of intellectual property. So the main thing is that when so many people are creating intellectual property for you, how do you safeguard it? How do you ensure that you are the owner of that intellectual property? The first and foremost step that you have to take is that there's an agreement called work for hire agreement, which has to be signed with every individual. This agreement basically states that if you are creating an intellectual property under this agreement on my instructions, every intellectual property that you create will be owned by me. So that ensures that when 50, 100, or even 200 people are involved doing different tasks during the film production, whatever they create from scratch, that will belong to me and me only. Nobody else can come in the future and say, I have the intellectual property right over that particular part of the movie. Because if that happens, that just opens the floodgates of litigation. Many cases can come. So work for hire agreements are an absolute essential, coupled with, of course, the non-disclosure agreements, which just go without saying. In addition to these, there's another very important aspect. We don't only create intellectual property during the film production. We, in fact, actually hire or rather purchase intellectual property as well. To cite an example, for example, I'm creating a movie and now I need 6 songs for my movie. So I approach, hypothetically, I approach a film studio, rather recording studio, say T-Series. And I tell T-Series that I need 6 songs. 2 of them have to be romantic songs sung by, say, Arijit Singh. So now T-Series licenses those 6 songs out to me. Now the thing is that I do not know whether T-Series actually has rights over those particular songs. And for me, in fact, there are no way of knowing it either because those contracts with the artists are confidential. So what I do is that when I'm getting or licensing these songs, I have indemnification clauses in my agreement. If some artist in the future sues me that you are using my songs without my permission, T-Series will be bound to indemnify me. If there's a big penalty, they will have to recompense or rather compensate me for that. So these two are absolute essentials. You need to have the work for hire agreement and the indemnification clauses in place. In addition to these,
I recently dealt with another matter. So there was this movie, I'd rather not take name. This was an independent filmmaker who created a movie on a very small budget about how terrorists recruit small children for their violent purposes. So this person, how independent movies are made, first of all, is that this person requested a cameraman friend to do the camera work. He requested an editor friend to do the editing and requested a couple of actor friends to do the acting, who are not paid, of course. And these people, they do not have any idea about any contracts which have to be signed. So everybody comes, act in the movie, do their tasks, but there's no agreement or contract whatsoever. So now, peculiarly enough, another thing was that this person took a loan of about rupees 10 lakhs from another person, a relative basically. And this relative said that I want the title of a co-producer in the movie and you can pay me whenever you want. Now this movie became a huge hit. It wasn't released theatrically, but it made it to a couple of really big film festivals in Europe and it became a hit. And then Netflix approached them to buy the movie. Now the problem was that when Netflix went through the paperwork, they realized that there's absolutely no contract with anyone. So just think about it. I took a loan, I put his name as a co-producer, but there's no agreement governing our relationship. So what if I didn't repay the loan? And if I did not repay the loan, can the co-producer claim rights over my movie? So that's a big risk for Netflix, because if they pay you a certain sum right now and they tell you that we are purchasing your movie, and then the other co-producer comes and say that's my movie. So then you will be lingering in courts for a couple of years to come. So the point is that you need to have the paperwork in place with everyone concerned. And Netflix in that case was quite generous. The people, they were quite generous and they allowed us time to finish off the paperwork. So we had to retrospectively get into agreements with the parties, get no objection certificates. But that took time and that doesn't usually happen. That was our luck that they gave us time. Usually if you can imagine that Netflix is one of the largest platforms you can come across.
Amazon also, Netflix has come in. Yeah.
Exactly. And somebody who is an independent filmmaker who does not belong to the league of Rajkumar Santoshi or Karan Johar, for him, this movie to be on Netflix is a big deal. But just because of this lack of paperwork and lack of protection, he could have lost it in entirety. So that is one of the main things why paperwork is important. So, there was this saying that back in the 1930s, Lord Emery once wrote a letter to Lord Linlithgow, who was then the Governor General of India. He wrote that twice armed is he that has his quarrel just, and thrice armed is he who gets the blow in first. Meaning thereby that you can get the best of lawyers in courts, you can have the best of arguments. But another person who has every paperwork, all the IP is protected, all the contractual work is watertight, that person will always have a hand above you. And the point is that even if you go to litigation, despite doing all this, saboteurs are always there. Even then, you will always have the upper hand. And you know that there's a very good chance eventually that the result will come in your favor. So the bottom line is that contractually securing your IP is very, very important.
Correct, Siddharth. Now, of course, this was very important part which you said about the copyright and its being an idea, and that dissolves into the second one is there are a lot of independent filmmakers, like directors, producers, a lot of independent filmmakers who are involved in artwork, cinema, who often, encounters problems pertaining to intellectual property as usual. Now, either due to casual attitude and towards its protection or lack of funds. The secondary part is very important. What would you advise to these professionals who takes this thing in a very casual way, not really thinking about it?
I think it's better to understand first what is artwork cinema and what is mainstream cinema for our viewers. So mainstream cinema is when you come across these movies like Kabhi Khushi Kabhi Gham, Avengers, Guardians of the Galaxy with all these leading actors. That is mainstream cinema. Artwork cinema is sort of a niche area in filmmaking where only a very particular set of filmmakers indulge. So artwork cinema is basically they are pieces of art, which are meant to be appreciated only by people who understand that. For example, if you take a Picasso or a Da Vinci to a random person on the road and he would say, why are you showing me this? He cannot appreciate the painting. But if I take it to a connoisseur of art, he would end up paying millions for it. So that is the difference between artwork cinema and mainstream cinema. So whenever we talk about film festivals and independent films, they're mostly concerned with artwork cinema. And considering that artwork cinema does not really have a big audience, the budget of these movies are really small. So independent filmmakers don't have the resources that a film production studio has to get a battery of lawyers doing all your paperwork and registering all your intellectual property. So they have to be really smart. You have to think very practically what I have to do. So when you don't have any finances to hire a lawyer, the first thing, as I mentioned, that these contracts, the work for hire contract, they are all over the internet. You could just download a copy, edit it, and use it. That's of course not as good as getting a lawyer, but something is better than nothing. So that is one part. But as far as these young independent filmmakers are concerned, speaking from a very practical perspective, one of the major problems that they have, which give rise to a lot of litigation, is that these people do not know that their scripts or their stories have to be copyrighted or rather protected. They just take a story that they have and narrate it to a filmmaker, a leading filmmaker. And but what is stopping these filmmakers to using a story and making a movie? Nothing. And this happens very frequently. I'll give you an example. We must have seen these movies last year. One of them is called Bhalla, and the other one is called Chaman. So these were made by two leading film studios in India. And they're a story about a young man in his 20s who loses his hair and the problems he has to deal with on a daily life. So the thing was that this man who, I'll just stick to the facts of the case. I would rather not deliberate on who is right or who is wrong. This man narrated the story to a certain film producer. And he said, I'm not really impressed. I don't think it's going to work out. So I'll pass. So he then went on and narrated the same story to another producer who was quite impressed. So he said, let's start working on it. What happened was that few months down the line, this person realized that the person to whom he had narrated the story earlier in the first place, he had already started the production of the movie. And in fact, both the movies were bound to be released in the same week. So you can imagine, how big a financial distress that can be. And this person did not have a copyright. So he can't really go to the court and claim that it was my story. It's really hard to do that. So the point being that lack of copyright can put you in a lot of trouble. And as Mr. Datta mentioned that, you can have a registered post and not open the envelope. So I'll just tell you a very practical perspective of seeing the modern era. If you're going to narrate a story to a particular production house, what you can do is write an email and put the story as a PDF attached to the email. And email it on the official email ID of the production house before going for the meeting or the narration. So how that helps is that would not, of course, give you a copyright, but rather when you go to the court, you can show that you narrated the story on this particular date to this person. So that actually helps. That is a modern way of doing this. In addition to this, if you have an idea of a reality TV show, so of course, reality TV shows do not have a story. So, you can't really get a copyright on this thing. So they have a thing called a concept note, which is basically a concept of the entire show, having all the entry cases involved therein. And they put it in 10 or 15 pages. Even you can get a copyright on that concept note as well. In fact, it happened in the first couple of years of the 21st century. There was a show called Rakhi Ka Swayamvar. To be honest, I bought that show, but it gave us a very important legal precedent. In this show, this person narrated the idea of the show to a producer. And the producer went on to make the show without giving any credits or money to this person. And he approached the court, of course. And the court held that this person should be given the rights, as in he should be given the credits in the show. And they allowed a monetary compensation to this person as well. So that's how important securing your IP is. If your story is already copyrighted, then there's a good chance that the person will not be able to remake it without your permission. Another very practical thing is that if you have a story and you need a copyright, first, it doesn't really cost that much. You can get a copyright for 10 to 15,000 rupees on your story. And a better thing is that there are these self-publishing houses these days, which publish your book on a payment of a certain sum of money. So for 25 to 30,000 rupees, you can get a book published. So the point is that you go get a book published, they grant you an ISBN number and a copyright as well. So once you have these things in your hand, these not only help you secure your IP, but these act as a deterrent as well to anybody who would want to imitate them. So these are some practical considerations that I feel are necessary for the budding filmmakers to keep in mind.
That was a very interesting aspect which you mentioned on the reality show, Siddharth. So going into a more objective part of the IPR is that now, once the copyright expires, what happens? What happens to the copyrighted work?
Yeah. So I came across this. So basically, copyright ends in 60 years. Now the problem is that Bollywood basically boomed onto the scene in the 50s and the 60s. That was the era of Raj Kapoor, Bharat Bhushan, Manoj Kumar, and Devanand. So these people, they produce the movies themselves. Now the problem is that the 60 years are expiring from the production of the movies, and their children and grandchildren have been getting a lot of royalty from these movies. But now that the copyright expires, the work is in public domain and anybody can access that. So that is of course going to result in a lot of financial, income that you could have had. But to be honest, there's no way out of it. I mean, as the law says, after 60 years, the work has to be in public domain.
So it's for everybody to,
Indeed.
yeah. So now, what is the scope of arbitration in such disputes involving copyright works?
See, the first thing about arbitration is that arbitrations arise out of contractual relationships. So you need to have a contract to get into an arbitration. But again, the point is that if somebody is stealing your work or infringing your copyright, there's a very, very good chance that they don't have a contract with you. It wouldn't really make any sense. So if you do not have a contract, arbitration, at least in India, would not be permitted. But there are a lot of countries in Europe and several states in America which actually permit that. So they are very pro arbitration. They're very liberal when it comes to arbitration. So if you are in those jurisdictions, then maybe it can be permitted, but in India, it will not be permitted.
Okay, thank you so much, Siddharth. And again, when we, subjectify your, the way you expressed yourself and you shared the prominent part of copyright is an idea. And if that idea needs to be expressed, it has to be through a medium. And then the second thing which you said was, of course, there has to be a signed agreement amongst 200 people who are working and in that part, and you are the owner of that particular creative. And the other thing which you said, the difference between mainstream cinema and artwork cinema, because most of the people even now, they do not know, because we have got this huge population, and that's the way you have said that was so important. Another aspect, which is again the clauses of indemnifications and hiring international property, the combination. And last but not the least, I must say that the way you have said about, securing your IPR in any format, and moreover in the reality show. And you've given such a wonderful example of the Swayamvara which happened. And well, thank you so much, Siddharth. And I cannot thank much on behalf of DAFE, which is a Diorama International Film Festival, to the eminent panelists today. And of course, thank you so much to Justice Sen for coming by and contributing his time in spite of quite an eye surgery. Thank you so much, Justice Rajive Bhalla, and you have got this amazing humor when you said that, I'm a big critic of Indian cinema, and how wonderfully you have put in an point when you said that nothing can be parallel as much as 60s and the 70s music. And thank you so much, Mr. Datta. I cannot, and the viewers cannot thank you enough, because you have simplified IPR in a matter of 15 minutes, such an expansive evolutionary subjects. Thank you so much on behalf of the viewers and young lawyers who are coming out, the students, the legal students, law students. That would be so amazing. And thank you so much, Siddharth. I mean, I cannot thank you enough, because this has all been organized and done so well. And the way you have said about, again, in a very simplified way, about the IPR in Indian cinema, the massive Indian cinema, which boasts of multi-billion crores, and I do not know how much, as we cannot see. And till, as so rightfully said by the eminent panelists today, the legal panelists, that, well, India has been late in really understanding the IPR, but we are never too late. So, Jai Hind, and it is such a wonderful thing. Thank you so much. This is from Advocate Carlyta Mohini. Thank you so much.
Thank you.
We also thank you from the whole Diorama team for joining us today.
Thank you very much.
Thank you, sir. Have a good day. Have a good night.
And it's my, I do not know today when I sit down with this eminent, pride of India. Today I am so indebted and so feel blessed by God to be there with this amazing, blissful legal panelists and pride of India in our legal panel today.